Good afternoon, Judge Smith.
Good afternoon, Chief Justice.
How are you this afternoon?
I'm fine, thank you. Just seem very far away.
Well, I suppose you must have the screen there where I'm much closer to you.
Yeah, and I can see that. Thank you.
Thank you very much for availing yourself for this interview for one of the positions in the Supreme Court of Appeal. We appreciate it.
Thank you, Chief Justice.
I'm going to ask you questions, and later I will allow the commissioners to also ask you questions. As we ask you questions, we will be guided by the selection criteria that we have adopted for the selection of judges. We may ask you questions robustly, but nobody is here to try and humiliate you or to treat you with disrespect.
Yes, thank you, I understand. Thanks, Chief Justice.
Thank you. Do you hold a BA law and an LLB and a diploma in labor law?
Yes, that is correct, Chief Justice.
Please bring the mic closer if necessary so that we can hear.
Yes, that is correct, Chief Justice.
Okay, all right. You got it from, you got the BA law from UDWC?
It's UWC, University of Western Cape.
Western Cape?
Yes.
And then you got the LLB at Rose University?
That's correct, Chief Justice.
And the diploma at UCT?
That is correct, Chief Justice.
Yes. You were admitted as an attorney in 1984? Was it 1984?
Yes, yes, that is correct.
Yes. How many years did you practice as an attorney before you got appointed as a judge?
I practiced until 2010 years, and I was appointed as a judge in 2010.
So that must be about 26 years?
Yes.
1984 to 2010?
That much, yeah. It was a long time. I remember just waking up one day and feeling that I'm tired of this. I need to go and do something else. So it was a long time, yes.
Yes. And you were appointed to as a judge in the Eastern Cape Division.
Yes, that is correct. And my seat being Makanda,
yes,
which was Grahamstown at the time.
In 2010.
In 2010, yes.
So you have been a judge for about, what, 13 years?
13 years, together with my acting stint, it would be 14 years, yeah.
Okay, how long did you act continuously before you were appointed?
I think the longest period was about 3 months. I think that was in 1998, and thereafter there were intermittent stints of about a month or 2 months. But it wasn't continuously for the entire year.
Yeah, but I don't think you can count those that are not continuous. But if you get appointed and you act continuously until you get appointed permanently, I can understand.
Yeah.
Well, I don't think you can take all the bits and pieces over 10 years or so and put them together.
Yeah. But I've been told that they all put together.
I know what you're talking about,
yes.
but that's for another purpose.
Yes, I understand.
Even there, I don't know if it's correct, but I know it's done.
Yes.
So you have been a judge for about 13 years.
Yes, that is correct.
And how many stints have you had in the Supreme Court of Appeal, acting stints?
I think there were 3.
Yes.
There were 3 terms. That
3 terms?
Yes.
Okay.
And last term ended, I think, on the 30th of May last year.
Yes.
Yes.
In the High Court over the years that you have been there, how diverse is the work that you have been exposed to?
It was relatively
in terms
diverse.
of branches of law.
Yes, Chief Justice, you would probably have seen from my judgments that I annexed. There's been quite a range of law in the Eastern Cape, particular in certain certain centers, like when you are sitting in Mthatha, you get a certain type of case. When you're in Bisho, it's mostly cases against the minister of the MEC for health and those type of things. And then Makanda and Kabeja, you also have different type of cases, but they were relatively varied.
Yes. Yes. Okay. And how did you find the experience you got in the SA?
Yes, it was interesting and challenging. Unfortunately, Chief Justice, the first 2 terms were during the height of the lockdown. So we had to do everything virtually. And that was a bit of a letdown because I obviously wasn't exposed to the culture and the feel and being there in Bloemfontein at the SCA. But then the last term, I was fortunate to actually be there physically. So it was challenging. Different work, obviously, different style of judgment writing, which I must say appealed to me because I do believe in concision. When you write a judgment, that you try to say what needs to be said and not unnecessary things. And so I thought that I took to that type of judgment writing relatively quickly into my acting stint. You still obviously dependent on the more senior judges to make suggestions and try and shape your judgment, but overall I enjoyed it. Something that I enjoy about being a judge is writing judgments. So it was very enjoyable, and of course it's a steep learning curve. You have to swim or you're going to sink. You have to work very hard. It's a lot of work, and I tried to make sure that I got my judgments out, at least present them for consideration to the senior judges or the presiders in good time. And I think I've been successful in doing that.
Yes. In your in the High Court, in the light of the diversity of work that you are telling us about, you probably have had an occasion to deal with a case where you were asked to invalidate legislation on the basis that it's inconsistent with the Constitution. Have you?
Yes, I was fortunate to have two such occasions.
Yes.
And I wrote 2 judgments. Both of them went to the Constitutional Court.
Yes.
I didn't annex the one judgment which was on the constitutionality of an ordinance governing impoundment of cattle in the Eastern Cape. But then there was the Shoprite Checkers matter, which I have annexed, which deals with the issue of liquor licenses and whether that actually constitutes property for the purposes of the protection in terms of Section 25 of the Act. That case also went to the Constitutional Court, and there were different judgments. The judges had very disparate views about it. Some of them, at least one of the judges agreed with me entirely, and the others disagreed with me, but the majority agreed with me regarding the finding that a liquor license constitutes property for the purposes of Section 25 of the Constitution, and therefore immune to arbitrary deprivation. And they were also with me, if I remember correctly, on the issue of whether or not there was an actual deprivation that took place. Where they sort of parted ways with me and disagreed was on the issue of the justification for the deprivation which was provided by the provincial government. And they said that I should have found that what they put before me was sufficiently to justify that interference with the right and the extent of it. And the Mdodana matter was also quite interesting. In that case involved the validity, constitutional validity of an impoundment ordinance, which sought to allow deprivation of property of cattle without judicial supervision. And also, there's also some mad provisions which entitled the landowners to decide on penalties for whoever's cattle encroached upon their property, and so there was the issue of the discrimination against the landless as well. There were other issues as well, but eventually what happened was that the question then arose whether that ordinance constituted provincial legislation for the purposes of reference to the Constitutional Court for confirmation. And I found that it did. I think counsel arguing for Mr. Mdodana was clever enough to say, look, even if it does not, it will make sense to refer it to the Constitutional Court, because the issue was that the area of the erstwhile Ciskei was excluded from the operation of the ordinance, and then there was also issue of abolition of the lawmaking entities that gave rise to that ordinance. But the Constitutional Court, in essence, then, I think, in effect, confirmed my finding regarding the unconstitutionality of those provisions, but then said that it wasn't necessary for it to be referred because it did not constitute the provincial legislation for the purposes of referral to the Constitution and confirmation by the Constitution. So those two, I mean, apart from I've also annexed other judgments which do not specifically deal with the issue of repugnancy of legislation. But those
don't
are
deal
there.
with those
Yes.
because they fall outside of my question.
Yes, thank you.
So you are familiar, therefore, with how a judge is supposed to go about determining whether legislation is inconsistent with the Constitution.
Yes,
Would you like to share that with the commissioners, how you go about it, what you look for, and so on?
I think the starting point would be, if I'm speaking under correction, I'd be Section 36, I think, which provides that the rights enshrined in the Constitution can only be limited by a law of general application, which would be reasonable and justifiable in a society based on, I think it says, human dignity and freedom and equality and those type of things. And then the section also says what you've got to take into account, for example, the content of the right that is sought to be infringed, the purpose of the limitation itself and the extent of the limitation, the extent to which the limitation relates to the or the purpose for the limitation relates to the deprivation that or the limitation, or sorry, the extent to which the limitation relates to the reason for the interference with the right. I think there may be one or two other issues, but those are, and of course there's the issue of proportionality as well, whether there were any lesser means to be achieved. So essentially, if you look at it logically, the starting point, I think this is something that is often overlooked because I'm not sure whether it will ever arise in South Africa, but the starting point is actually whether let's just call it a rule that seeks to limit a fundamental right, whether that rule constitutes a law. And I'm saying this because I have had the privilege of, in the past, when I was still an attorney, I think you will be able to remember that in those days in the Ciskei, and I think in Botswana as well, there were, justiciable bills of right, which those governments in the Ciskei, it was the military government that adopted it. So the African National Congress then gave us instructions to challenge, in particular, the law relating to the ban on meetings, which was just some crazy provision that says if more than 20 people gather, it is unlawful. And then, of course, the law relating to detention without trial. So
yes, but
the provision,
you didn't deal with that as a judge, isn't it?
No, I didn't.
My question,
my
question is how you how you deal with the determination of the consistency of
Yes.
legislation with constitution, and
Yes.
you have given an answer.
Yeah.
You have given your answer to that. My next question is about the two types of discretion that we find in law. Are you familiar with them? If you are, what are they? What are the differences between them?
Yes,
and what is the legal significance of knowing the difference between the two?
Yes, thank you, Chief Justice. Here, I am familiar with them. I think I always regarded the terminology or the appellations that were accorded to these two different types of discretions as very confusing, the way that I looked at it, because it almost seems to you that the what is termed a narrow discretion is in fact a wide discretion, until you realize that what it means only is that the reference is not to the scope of the discretion, but the description of the type of discretion. So it means, for me, I've always been more comfortable with saying that it is a true discretion instead of a narrow discretion. And for me, when the importance always arises when you're sitting as an appellate court, where you have to decide what type of discretion is it, which will then inform the basis on which you may or may not interfere with the exercise of their discretion by the court à quo, and also the circumstances under which you can substitute your own discretion. So the issue of the true discretion for me has always been in a case where there's various options open or causes open to the judge, and the judge in the court à quo has decided to take a particular option. And when I ask myself the question, was it wrong for the judge to take that option? And I have to say, well, I would have done it differently. Then I know it is a true discretion, and I can only interfere if there was misdirection, either insofar as the factual, the application of the facts or the law is concerned, or some other irregularity. And to me, that is the true discretion. The wide discretion, which I prefer to call the loose discretion, because it's loose in the sense that it's a discretion that it's a loose reference to a discretion, which means that that what happens is that the judge in the court à quo would have had a particular set of facts before him or her, and would have exercised a discretion on the basis of those facts. And in that case, you as a court, as an appellate court, would be equally empowered, having those same facts before you, to take a decision. So you don't have you don't have to interfere only if you can say that there's been misdirection on some other irregularity. If you think that it is wrong, then you can interfere. Now, in terms of the types of discretion, I think the obvious ones of a true discretion, exercise of a true discretion, relates to damages, the issue of damages, and I think costs. And I would also say when a postponement is sought. The narrow discretion, I think, would be in circumstances such as a finding regarding the existence of substantial and compelling circumstances where that decision is taken on the basis of a certain set of facts. So if the appellate court is of the view that the quota quo was wrong to find that there were compelling and substantial and compelling circumstances, then I think the court is at liberty to interfere on that basis. So I think that is, for me, that is the difference, and that's how I approach it as an appellate, sitting in appellate jurisdiction.
Did you say determining whether there are compelling, special and compelling circumstances is a matter of discretion?
Well, I would say that and that's the reason why I said that if it is a discretion, it would be in the very loose sense, because there you don't, as an appellate court, you don't have to you don't have to make a finding of irregularity. The only thing that you need to be sure of is that the quota quo was wrong, either to find compelling circumstances or not to find compelling circumstances. But maybe that is not a good example. Probably a better example of a exercise of a discretion in the loose sense, it would probably relate to liquidation proceedings where a case has been made out for commercial insolvency of a company, which then says that the judge has discretion, even though that has been established as a discretion to whether or not to liquidate the company. But that discretion would be in the very loose sense. So if it is there, then he or she must have very, very good reasons why that order is not granted.
Did I hear you correctly that you said to see whether you are dealing with a true discretion, you ask yourself the question whether you could have taken a different decision? Did I hear that part correctly?
Yes, I did say that, but in the context where I say that even if I did, if I could have had a different view, it is not a basis for interfering, because a true discretion had been exercised, and I can only interfere on the basis that I have described.
So how does one see which discretion one is dealing with?
Well, if it is the discretion in the true sense, it would be where the court had various options open to it and has chosen one option or particular course, and neither of those can be termed as wrong. So that would be the exercise of a true discretion. But in the other sense of the discretion, where the decision has just been made on the basis of some other factors or factual matrix, that would in any event be before the appellate court, then the court is more at liberty to interfere if it thinks that the exercise of their discretion was wrong. In other words, he doesn't have to first be convinced that there was some irregularity or misdirection on the part of the quota quo.
Deputy President of SA.
Thank you, Chief Justice. Good afternoon, Judge Smith.
Good afternoon, Deputy President.
Let's just get this one point out of the way. Did I hear you correctly to say that when you want to determine whether there are substantial and compelling circumstances that entails exercise of a discretion?
No, I was trying to say, and maybe I didn't make myself clear, I was trying to say that in the context of, for example, a criminal case where a sentence has been decided on, and maybe I should have said that, that is the exercise of a sentencing discretion on the part of the quota quo, and we know under what circumstances that. But where a decision has been taken regarding the existence or non-existence of substantial and compelling circumstances, the appellate court doesn't have to be convinced about misdirection. It will look at the facts that were before the judge, and it will decide whether or not those circumstances were in fact present.
Thank you.
Okay.
Well, can I just follow up if you are not following up? Are you saying, Judge Smith, when a court decides on sentence and an appellate court has to deal with whether to confirm or set aside that sentence, are you saying that a decision on sentence to set aside on appeal a sentence doesn't require there to have been a misdirection on the part of the lower court?
No, I'm saying the contrary. I am saying that is a type of discretion where there has to be some basis on which the court will interfere, including a misdirection.
Well, I certainly had the other one, the opposite.
No. Sorry if I didn't make myself clear.
But even there, I'm surprised that when the Deputy President of the SA follows up on this question of you using the example of special and compelling circumstances, that you now say you actually intended to say a decision on sentence, because I thought you were quite clear that you were talking about deciding whether there were compelling circumstances in a case. I even asked you a further question, and then you said, maybe it's not a good example, but you didn't say, no, I actually meant that when you decide a sentence. You didn't say that.
Yes, maybe I didn't make myself clear. I'm sorry about that, Chief Justice.
Deputy President.
Thank you, Chief Justice. In paragraph 12 of the questionnaire, you mentioned there that you have one publication in the case for more accessible judgments.
Yes.
And what inspired you to write that article?
What happened, Deputy President, was that I was approached by Judge Madlanga. He was looking for people to make contributions to the SAJ journal, and he asked me whether I could write something on judgment writing, but he said that He wants something that would make for easy reading and would be sort of entertaining as well. So it wasn't meant to be a scholarly work.
Thank you. You would have been provided by the Secretariat with the comments from law bodies and other interested parties. The one that I want to take you through is the letter from Mr. Makanya, who is an attorney in
Yes.
East London.
Yes. I can just,
More specifically, Part C of that letter, which relates to you,
yes.
and paragraph 6 thereof.
Yeah, can I just get the file that was placed here before me?
Yes, by all means, just.
No, that. I thought, yeah, thank you. Thank you. They just brought it to me now. Can you just help me, Deputy President, by, is it already paged? Oh, okay, there it is. Thank you. Thank you very much, I've got it.
Thank you. It's where Mr. Makanya says that your departure from the Eastern Cape, if you were to be recommended for appointment, would destabilize the division.
Sorry,
And that
sorry, Deputy President, which paragraph you're referring to?
Part C of the letter,
Okay,
which is on page 6,
yes,
paragraph 6.
it's paragraph 6, yes, I've got it, thank you.
He says therein that your services are needed in the Eastern Cape in order to stabilize the division.
Yes. Yes,
Meaning-
I see that, yes.
What's your response to that?
Well, I've been in the Eastern Cape for 13 years now, Deputy President. I think I have made my contribution there. There are other very competent and senior judges in the Eastern Cape, and as much as I value my own contribution, I don't think that it is going to destabilize the division at all.
You would be aware that in the recent past 3-4 years, the SCA has lost about 16 judges with their wealth of experience and expertise. Are you aware of that?
Yes, I'm not sure of the number, but I do know that there has been attrition in that sense at the court.
And do you think that if you do an honest self-introspection and self-assessment, your elevation to the SCA would be truly deserving and would go a long way to mitigate that loss of expertise?
Yes, I would, in all humility, Deputy President, I would say that I am ready to make a contribution. As to whether initially I can help to fill that void, because there's been a wealth of experience that has left the court. I am not going to say that I can simply step in and replace judges who have been there for many years and who have amassed a wealth of experience. But what I can say, Deputy President, is that I have, during my 3 acting stints, proven myself, I think. I have worked extremely hard. I was always prepared for the hearings. I knew the records inside out. I could engage with counsel during the hearings, and I thought that I asked pertinent questions which helped us to better understand their arguments and to decide the issues. I was also able to coherently and substantively contribute during the post-hearing conferences where I made my views known. I have written, I think there were 5 judgments. Those judgments were presented to the researchers and then to the senior judges in good time. I have had comments on those judgments. There's just been one judgment where there was an engagement with the presider. I'll come to that now. But otherwise, the contributions were mainly of stylistic, grammatical, and those type of. There's not one occasion that one of the judges told me that you have missed the ball completely. The one judgment that I am referring to, where there was a bit of a debate, was, you will recall that you presided in a matter involving an advocate that claimed some fees from the council, and there was the issue of hearsay evidence that had been presented, and when I presented my judgment to you, you called me and you said, look, do we really have to go into this issue of the hearsay evidence? Is it really an issue? And we debated it, and we agreed that the fact that that issue was raised quite extensively in the heads of argument and also during argument, that we need to deal with it. And I think we then settled on the basis that you said that we must just tone down the judgment insofar as the paragraphs that related to the hearsay. I do not recall any other judgment where there was any substantive complaint about my judgment writing. I would respectfully refer to the comments by the GCB. Those are people who appear before me regularly. Many of them were on the receiving end of my judgments, one can assume. And my judgments are also here for the commissioners to look at and to consider. And I think that on a reasonable reading of those judgments, they do evince that I am able to internalize legal issues, that I can summarize factual, relevant facts in a concise manner, and that I can give a reasoned judgment on the basis of the application of the facts and of the law. So I would venture to say that if I were to be appointed, and working hard and making contribution with 13 years experience as a judge, varied experience, I can make a contribution on the bench.
Thank you. Today is the 3rd of October, second day of these interviews. On the 4th of October, a year ago, on the second day of the interviews, you appeared before this commission, and I raised with you everything that I wanted
Yes.
to explore with you.
Yes.
Would you be happy if we were to leave it here at this stage today?
the Deputy President is, I would certainly not say that those must be swept under the carpet. But yes, you did. If I recall correctly, I don't know if you want me to speak to those issues that you raised.
No, not at all.
Yes, no, then I won't.
Thank you.
But I have taken cognizance. Can I just say this in conclusion, that one learns very quickly as a judge that you need to be receptive to criticisms, constructive criticisms, whatever comes your way. You need to commit to introspection, and that's how you grow. So I am definitely not going to be defensive about what anybody says about my abilities. I'm just asking that I be judged on the basis of what I have presented here. And I think that clearly evinces that given an opportunity, I can make a contribution.
Thank you. That will be my parting shot.
Thank you, Deputy President.
Thank you, Chief Justice.
Thank you, Minister. Covered. Thank you. Commissioner Nyambi.
Thank you, CJ. Afternoon, Judge.
Good afternoon.
I'm
Who am
this
I?
side.
Oh, sorry, sir. Thank you.
It's one question from my side.
Yes.
It's linked to what has been asked by DP. Last year, same month,
Yes.
same number of candidates, but last year it was 5 vacancies. This time around, it's only 4.
Yes.
Probably if you can have the opportunity to share with us anything that has changed between then and now.
Yeah.
Because last year, if I remember very well, the last time you acted at the SCA is last
Yes.
year, May.
Yes.
Convinced us that between what we discussed last October and now, that we must this time around seriously consider,
Yeah.
so that you can be able to be given an opportunity to go to the SCA.
Yes. Well, thank you for that question, because I almost omitted to. There's just something. If you can just allow me to just correct something, Chief Justice. In my CV, I stated that I would be acting at the Labour Appeal Court from August until December. That has changed somewhat, because what happened was that even though the minister appointed me to act until the end of December, my JP couldn't release me for the 4th term, so he then approached Judge Wagley to send me back and to then try and get somebody else. And between the two of them, they've arranged and then compromised on a situation where I would be going back only for 2 weeks in November. So that was at the time when I was already appointed by the minister. So I just wanted to correct that. The other thing which relates to Commissioner, to your question, is what has changed. You will recall that I had to do quite a bit of an egg dance last time regarding the number of my reported judgments, which I declared to be 4 or 5 now. I must confess, I didn't give myself enough time to check on my reported judgments. I always understood that my judgments were many more than those that I have disclosed. And the GCB, in fact, in their comments also said that I am unnecessarily humble regarding my judgments, my reported judgments. On this occasion, and of course I couldn't come here and say that, well, I think it's about 15 or so, when I've only declared 5. So I had to answer the question on the basis that I only have 5 reported judgments. So when I checked, you'll see that the reported judgments that I mentioned, there are 10. But actually, because we were just asked to mention 10 judgments, but actually I've got about 18 judgments which have been reported, and I missed out on a number of those because I just didn't give myself enough time to do proper research and go back. Some of them go back about 10 years or so, so it was quite an effort to get to all of them. So that is the one thing that I think puts a different perspective on my application. The other thing, of course, is that I've acted in the Labour Appeal Court also, which was also a very empowering exercise, experience for me. I, as you heard, I do have some qualification in labor law, but I practiced labor law when I was still an attorney, and it was mostly overtaken by political work that my firm was doing. So it was quite something for me to get into. I was allocated 7 judgments in the first term. The JP explained to me why he allocated those judgments. Well, I think that, as I say, it wasn't easy because I was hoping that the labor law practice was going to be like riding a bicycle, that it comes back to you naturally. It was a bit more complicated than that, but of course there are experienced judges there, and I could lean on them. And I think that I was able to do what I was called upon to do. 2 of my judgments have already been delivered. 2 have been are with the senior judges for their consideration. 1, there's only 2 left, which involve matters that were heard either last week or I think it was last week only. So those 2 judgments, I'm working on them now. So, sorry, I must just say that I was allocated 7, but 1 of the matters settled on the morning of the trial. So that judgment then fell away. So I had 6 judgments all in all. So what I'm saying is that is that added experience, and I think an indication of my ability to swim when I'm thrown in at the deep end and make a contribution in a relatively short space of time.
Thank you, Judge Smith. Thank you, CJ.
Thank you. Commissioner Marumwahai.
Thank you very much, CJ. Good afternoon, Judge.
Good afternoon.
I was quite surprised when you were asked to speak about significant judgments that you did not refer to ACAS versus ACAS. I'm not sure if I'm pronouncing that correctly. The one that deals with consent orders, the maintenance consent orders, where you clarified how the Prescription Act applies in respect to that. Do you remember that matter?
Yeah, I know that case, yeah. It was all about whether maintenance order is a judgment debt for the purposes of the Prescription Act, yeah.
Yes, and you got a concurring sort of separate judgment which took the matter further, but ideally supported your view.
Yeah.
And I thought it was quite significant, so I was just surprised that you did not refer to it.
This is good to know that my view has been supported, because the Constitutional Court gave us a bit of a bloody nose in the Madao matter recently.
Yes, and I'm about to ask you about that.
I somehow had a feeling that you're going to raise that.
Yes, that's the judgment that I want to ask you about. And obviously it could not be part of your PEC because it only came out in August.
Yeah.
And the issues that I raised with you a year ago, they are dealt with in that judgment. What is just your general view in respect of what I put to you as an injustice at the time?
Yeah,
do you retain your views, or do you accept the Constitutional Court's views?
I think you're entitled to say, I told you so.
I will leave it there. Thank you very much, CJ.
No, the fact of the matter is that one must accept that colleagues and other judges are going to differ with you. I don't want to. I think the Constitutional Court has spoken, and we must accept it. But just to say that, that there's a very good reason why the law require when more than one judges would sit, more than one judge would sit, that it must be an uneven number, because judges differ. Even in the Constitutional Court, I've mentioned one case where there were different views, and sometimes it's not always that you feel because it's the same thing. If you sit in a court and there's 11 judges and 4 of them say, go this way, and the majority, 7 go that way, what happens in effect is that they're overruling the 4. And they're saying to them that, look, so you must accept.
No, I accept that, Judge, but the Mudau judgment is unanimous nonetheless.
Sorry?
The Mudau judgment is unanimous.
No, it is.
Yes, thank you very much, CJ.
Thank you.
No, it is. Yeah.
The one question rule will apply for the rest of the day. Okay, all right. Commissioner Baloi?
Thank you, CJ. Good afternoon, Judge.
Good afternoon, Commissioner.
Yes, Judge, I'm talking to you, I want to talk to you about the judgment in Nelane versus interim chairperson of board, Buffalo City
Yes.
Metropolitan. You remember that judgment?
Yes, I do.
Yes. Now, there are 2 issues. The second one has got a number of layers to it, but
Yes.
I'll try and just concretize them into 2.
Yes.
The first is you found that the matter is urgent or ought to be heard on an urgent basis.
Yes.
But your only explanation in that judgment is you say that the judgment was, you speak about an earlier judgment
Yes.
of Bloom. You say the judgment was, Bloom's judgment was delivered the day before the impugned decision was taken, and Bloom J's findings in respect of the above mentioned issues therefore remain very much opposite to this case. That's what
Yeah.
you say. And then the next thing you say, and this is where the only place where you deal with why you decided this matter is urgent, you say, I respectfully associate myself fully with the reasons provided by the learned judge for his finding that the facts put up establish that the matter is urgent, that the balance of convenience is with the applicant, that he has established a prima facie right, and that there is no other satisfactory remedy available to him. Now for context, this matter comes to you because there's been a termination of a
Yes.
contract of
Yes.
employment.
Yes.
And yet you say that he has established a prima facie right. You don't say what, and then you say there's no satisfactory remedy, which I'm not sure about, because these kind of disputes or complaints are everyday bread in the
Yes.
labor court, and
Yes.
that court has resolved these issues. And how, after termination of a contract, you get to say that those requirements have been established. It doesn't appear for sure in the
Yes.
judgment. That's the one issue.
Okay.
The second issue still relating to the judgment is that you find for the applicant, and you find on the basis that the termination, you say he has established that the enforcement of a contractual term which allows for termination of a contract of employment without notice will be against public policy. This is you explaining
Yeah.
why you're not giving effect
Yeah.
to the termination. Now, earlier on in the judgment, you say he was given 2 weeks' notice
Yes.
on termination, and yet the reason you find for him is that enforcing a term of a contract that says he's not entitled to notice is against public policy. I battle with that.
Yes.
And the second, and related to that, is that you make references to the motive for terminating when they did. You speak about what the CC has said
Yes.
about public policy and not enforcing provisions of the contract, but there's no link between those discussions, including Bidika, and how you get to say that his contract was terminated. In fact, how you say the contract, to the extent that it provides for termination without notice, is against public policy.
Yes.
I don't understand how in this judgment
Yes.
you've done that. It seems to be completely wrong. What do you say about that?
Yes. The first of all, just regarding the reasons for, or the, shall I say, the dearth of reasons for the urgency and others, I take the criticism, but the judgment was written in the context of another judgment that was granted by Bloom J, and I accept that if you read my judgment in isolation, it is a bit perplexing as to how I come to that. But if you ever look at Bloom J's judgment, you will understand that the issues that he found were like a few days recently, so those circumstances were still relevant for my decision. It wasn't an easy matter to decide. The whole basis for my intervention or refusal to enforce the term of the contract on the basis that it's against public policy was that it was such a blatant and brazen attempt to circumvent a court order. And the way, the deceptive way in which it was done as well, also motivated me to say that, yes, there is pacta servanda sunt, which is an important consideration, but in these circumstances, I was of the view that it is not proper to enforce to enforce the agreement. I rely on the public policy. I accept that it is not easy. We need to, when you deal with a principle that is such a founding principle of our law, like pacta servanda sunt, and you want to depart from that, it is not easy. But I really think that there must be small, incremental steps for us to develop the common law. I accept that that for the purposes of the commerce and for business people, certainty of covenants entered into, that they must be respected, it's very important. But I think the Constitutional Court, I think in Judicial, has been very clear that courts must be very wary of attempts to hide behind pacta servanda sunt, to do things, to sanction things which are clearly against public policy. And I found that in this case it is. It was a brave decision, but on the facts that were before me, I just decided that no, this just does not seem right to me. This is unfair. It is an injustice. And my view is that it would be against public policy. On the same basis, in the Labour Appeal Court, we have interfered. The first two urgent appeals dealt with the issue of restraint of trade, and we interfered with the restraint of trade in the one case in the scope, regarding the scope of the restraint, and the other case regarding the duration of the restraint, on the same basis that it is against public policy to keep people away from their jobs for such a long time. And if you want to do that, you really need to give very, very good reasons. So I accept your criticism. It is not an easy thing. I'm not going to convince everybody, but I do think that that we need to be true to the Constitution to develop the common law. It's going to be incremental steps. You can't just put on your gumboots and venture into that scenario. But I hope that, I hope I answered your question.
CJ, I'll abide your ruling that no further questions.
Yeah.
Could I just follow up this point, because I get the sense. I must first get permission.
Yes. Okay. Permission is granted.
Yes. Thank you, Chief Justice.
For one question only, Chief Justice.
No, you see, Justice Smith, I think the problem that is being asked is not a question of the substance,
yes,
but it is the question of the approach to the judgment, because the rule of law also requires that the party that loses a case must understand why they lost a case.
Yes.
And if the judgment is laconic, then it's also a violation of the rule of law, which is an obligation of the judge to write clearly, to reason clearly, and to explain why they have reached a particular outcome. I think what Commissioner Baloyi is trying to say is that the reasons are unclear, the legal justification is unclear, the conclusions don't follow from the premises.
Yes.
So that's one criticism which I think you should expressly deal with and not avoid.
Yes.
And then there is a substantive issue, which is around this question about pacta sunt servanda. Now, you are the second candidate who has said it is necessary to apply the Constitution to contract. But you have not given us an explanation methodologically of how this is to be done, because you say we must apply the Constitution to contract, but then you say, well, we must do it incrementally. Now, I end up not understanding what precisely, whether or not we are in fact committed to this Constitution, because we make a rhetoric about its application, but we never give any concrete example about how it will be applied. Now, that's a substantive question,
Yes.
but I really do think, in fairness to us, we
Yes.
must confront the question by Commissioner Baloyi head-on.
Yes. No, I understand. And as I said, first of all, I would take the criticism that maybe the reasons are not clear. And you are absolutely right. I mean, we write judgments. I always believe that the most important person that you address in your judgment is the loser, because the winner will look at the order, and if it's in his or her favor, not going to worry too much about your reasoning, but it's the loser who needs to be convinced that I lost the case and it was ruled against me for the following reasons. But I don't think I can take it any further to say, first of all, it was done on an urgent basis, extremely urgent basis. Secondly, it was done in the context of another judgment that had been granted, practically a few days before then. With regard to how we apply and advance the Constitution in this very vexed question of pacta servanda sunt, unfortunately, I don't have an answer beyond saying that the issue of public policy and the guidelines provided by the Supreme Court of Appeal in, I think, what is it, Prodwan's case or something like that, that I quote, I think it at least provides a basis for the courts to chip away on the primacy of this. And the issue is that what makes it even more difficult is the fact that concept has always been central to our contract of law of contract, and it still remains in the commercial sense for contracting parties. You know, the notion that if you enter into a covenant, you must be held to that covenant. It is still important, and it's going to remain important. And I think in Judicial, the Constitutional Court recognizes that it still remains an important aspect. It says it's not the most important consideration, but one of many other considerations. So perhaps in the future, Commissioner Mkatobi, if that matter comes before me, I'll take another small incremental step.
Thank you. Commissioner Barnard, on my list, you are the last one.
Thank you, Chief Justice. Good afternoon, Judge Smith.
Hello, Commissioner.
You were the author of a judgment with which J concurred, where it was an appeal in terms of the Attorneys Act against an attorney who had withdrawn the matter of her client or caused the matter to be withdrawn without the client's or against the client's wishes. And you overturned the finding of the KZN Law Society Disciplinary Committee. So I was wondering, just don't answer that, but just anecdotally, whether you aren't sorry about that finding, because that's probably competing with you for this position, for a position at the
No, no, the Commissioner, I think even if I wanted to go the other direction, I think the facts and the law were so compellingly in her favor, and I think it was conceded also by counsel for the Law Society. So perhaps yes, maybe would have thought, but not on those facts and the law. I think you've read the judgment. You saw that I think that it was Judge Dowd and I put together a convincing judgment that shows clearly that there was absolutely no dishonesty or wrongdoing on the part of the judge when she was still an attorney.
Now, my question on that is, don't you precedent for legal practitioners to act contrary to their clients' wishes?
No, I think we do. Sorry, I
Commissioner
Chief
Barnett, I'm not sure whether everybody heard the last part of your question. Are you there?
Yes, I'm here, Chief Justice. Can you?
yeah.
Yeah. Do you want to just repeat your last question?
Certainly, Chief Justice. The question is, don't you think that the finding is still precedent allow legal practice to withdraw matters contrary to the instructions of in future?
Yes. Now, I think we make it very clear that an attorney is bound, ethically bound, to act in accordance with instructions. I think the issue here was that she was unable to get proper instructions from the client. You remember there was this story about the client having stormed out of the building and she was trying to get hold of him. And she, in fact, consulted senior counsel who were around, and they advised her that you need to do, whatever you do must be in the best interest of the client. And our finding was that she did that. So I don't think that the judgment can be read as being carte blanche for attorneys to ignore the instructions of their clients.
Thank you, Judge. Thank you, Chief.
Thank you. The JP is the last one.
Thank you, Chief Justice. Judge Smith, good afternoon.
Good afternoon, JP.
I have 1.5 questions. I hope the CJ will allow the other half.
Yeah, because you haven't been asking lots of questions, I will allow the other half.
Thank you, CJ.
Okay.
I'm just interested in knowing your experience in the SCA, how it's been. Have you heard, or let me rephrase this way. I know the SCA to be, you get your records well in advance.
Yes.
When you hear the matters, you already, and once argument is finalized, you write, with a view to circulating and handing down by the end of that term.
Yes.
Have you had occasions where you didn't hand in your judgments, your allocated judgments, in the term when the matters were heard?
I don't, I'm speaking under correction now, but I don't think so. I have given my judgments during the term. They were not necessarily delivered during the term, but I think they were submitted to the senior judges during the term.
Thank you. That's the one thing. Have you had occasion where the presider or some senior judge involved in your appeals has had to come to you and say, why is the judgment not coming out? Or are you aware of any comebacks that you are unable or you are struggling to write SCA judgments?
No, there was nothing. As I said, except for that interaction between the deputy president and myself, that was the only, there was nothing else that was brought to my attention.
Thank you very much, CJ.
Thank you. We have come to the end of this interview, Judge Smith. We thank you once again for availing yourself for this interview. We appreciate it. You are now excused.
Thank you, Chief Justice, and all the commissioners. Thank you very much.
Thank you.